The Eastern Pavilion Banqueting Hall, comprising 2 beautifully decorated modern guest suites with seating capacity for up to 1,100 guests. An ideal choice for engagements, weddings, Mendi parties, exhibitions and seminars. Supported by the latest sound and video technology, air-conditioned and free Wi-Fi. Contact us today and see how we can make your vision a reality. The Eastern Pavilion Banqueting Hall, located on Featherstall Road South, Oldham. A perfect choice for your perfect day.
The contents of this program may not necessarily represent the views of UK24. And welcome to Know Your Rights, a program which looks at your legal rights within the United Kingdom and beyond for those people who are applying for immigration rights from across the world. But of course we concentrate upon the rules and the laws that are required for you to follow within the United Kingdom. And today we're looking at a very special area of human rights. Assalamu alaikum, Barrister Shazia, how are you?
Walaikum assalam, I'm fine. Thank you so much for inviting me here.
Excellent. Now, the last program, alhamdulillah, a lot of people watched in, they tuned in and they wanted to know about special statuses and fee waivers and family rights. So there may be some questions that come through in relation to that. But today, we want to concentrate on the category of human rights and what that means. So, Barrister Shazia, can you first explain for those people that are tuning in, what is this category about and who does it include when we talk about human rights?
Very well. Human rights applications actually can be submitted by the people who do not fit under the immigration rules requirement.
Okay.
So in certain applications, immigration rules requirements might be very strict and sometimes it's impossible to meet for some people. So this is where human rights applications start from.
Okay.
So human rights application mean where people have exceptional circumstances in their immigration history. They can submit the application under the human rights convention rights and human rights instead of submitting the application under the immigration rules.
So for those people that may not fit into the family category or a spouse category, but believe that they have a right, a human right to remain in the country, to actually be a resident in the country, or to have in terms of access to services and the laws of the country, then they fall under the category of human rights. How is that separate to asylum? Because asylum is a category in itself, isn't it? That is another category. Is that correct?
That's right. There are actually certain applications which can be submitted when people's asylum application are failed.
Okay.
So this is where human rights start from. Sometimes there can be circumstances when asylum applications can be failed. Sometimes there can be circumstances when immigration rules applications can be failed, and sometimes there can be circumstances when the applications under the European regulations can fail. But still, if their human rights exist, then their application can be successful. Now, the types of applications, what kind of applications can be submitted under the human rights is very important to just tell the audience in relation to the type of the application.
Yes.
So first type of applications, I will just stress on to that, is the 7 years rule applications.
Okay.
So
7-year rule, meaning that you have been in the country for 7 years, is that correct?
So under 7 year rules application, so there has to be 2 tests.
Okay.
A, the child should be born in this country.
Okay.
And the child should spend his or her life for 7 years in this country.
Okay. For a child application.
For a child's category.
Okay.
Under 7 year rules, so there has to be a child who is either British or is born in this country, whether or not he is British, but he or she has spent 7 years in this country since the date of his or her birth.
Okay.
So this is the first limb of test. And second test will be whether or not it's reasonable to remove that child from the UK. This is very important.
Okay.
People has to consider, sometimes people think that when their child is born in this country, so they take it for granted. They think that they might be eligible to apply under that 7 years rule and they will be successful. But most of the applications fail.
So these are, you're talking about the parents of the child. So is it correct that you're talking about an adult whose child is born in this country, so they may not have an immigration status, may have an immigration issue going on, but some people think that just because you have a child born here, automatically you will be given residency.
I will come on to that point, but first of all, I would like to explain who can apply under this category.
Okay. Okay.
If the child is born in this country, not only the child will be able to get the legal status, because if the child's parents do not have any legal right to stay in this country, then it will be difficult to assess what kind of immigration status the child will have. The child and the child's parents and the child's siblings.
Okay.
So all of the family members and the child can be entitled, can be eligible to submit this kind of application.
Okay, okay. And what category does that fall into? So does that come under, would it have to come into the 7 year rule?
So this is called a 7 years rule policy.
Okay.
And under this policy, not only the child, but also the child's parents, child's siblings, even if the child's siblings, for example, brothers and sisters, are over 18 years old, they can still apply under this category under the human rights basis.
So do they have to wait the 7 years then? So what happens in the 7 years? What category? Because could they be removed from the country if they have no legal status?
It could be, but if they have completed 7 years successfully in this country, in the meantime, it could be that they might have been submitting the different categories of application. Mm-hmm. It could be that they have been living here in another category.
Yes.
Or the situation could be any. We cannot just assume, because every situation differs from situation to situation.
So they may have ongoing applications which are live
and appeals.
And appeals. So there could be live applications or appeals, but no settled status. But once they get out of that 7 year period, then they are eligible, they could be eligible to apply under the 7 year rule policy.
To be eligible under this category, they have to meet 2 tier of test.
Okay.
The first one is that they need to show the relationship with the child.
Okay.
And it's very important. They need to show the birth certificate, UK birth certificate, and they need to show the other relationship requirement. For example, if their parents are married, they have to show the marriage certificate, and if the other children are born in this country, or if the other children are living in this country, they have to show the proof of relationship with the child, which could be family registration, which could be birth certificates, marriage certificate of the parents. All of these requirements needs to be established before submitting the application. Now, the second thing is in relation to the reasonableness test.
Okay.
So this is very important. If you can satisfy to the Home Office that this will be unreasonable to remove that child who was born in this country and has not been granted any status until today. But then if this application is not granted, then this will be unreasonable for the child to remove from UK, and this will not be he will not be able to spend a quality life in their returned country. So this is the reasonableness test. You have to prove with the
and how is that done? Because what is reasonable? Obviously, there's reasonable in the eyes of the law. Obviously, reasonable in terms of when we look at human rights and things like that. That a child who has spent 7 years in this country knows no language. There are language issues. There are cultural issues, and for them to be then sent back, or well, they're not sent back because they've never been there, have they? But because of the fact that they have no legal status here, because of their family situation, and like you said, it's about reasonable grounds, isn't it?
Yes, not only reasonable grounds, but also you need to enclose reasonable evidence as well. So this evidence could be the letters from social workers. This could be letters from GP or dentist. This could be letters from teacher. If the school has, if the child has been attending the school, has been attending the GP or dentist, so they can just write down in the letter that this will not be proportionate for the child to be removed to the country where he or she is going to, because he has already established a private life in this country.
Yes.
So this could be one of the arguments. And there could be, if the social worker is involved, then it could be the problem with the child's physical or mental health. It could be that the child is not speaking the language which is spoken in the other country. So every case is different from situation to situation. So everybody needs to establish their circumstances with the evidence.
One of the things, I mean, I'm trying to think back to when we looked at the other applications of family and spouse. One of the things that's coming out from this is that the relationship between the applicant or the applicant's family, in this case it could be their parents. I mean, child's not going to put the application, it's going to be the application from the family unit. Their relationship with professional services such as schools and health workers, social workers, GPs is very important, isn't it?
It is essential. Without these relationship, they won't be able to just to submit the application, and they won't be able to get the facilities from these institutions. So it's very essential, and it's I will say it's compulsory to have good relationship with the authorities, so that when you ask them to give you letters, so it's easier for you to ask them to provide you the letters which can prove that this child needs to stay in this country. And not only, this is very important, not only that child, in the meantime the other family member, for example, the child's parents, the child's brothers and sisters can also submit the same kind of application, and they will be granted leave to remain in this country.
To be able to keep the family unit together.
Yes.
Now, in terms of relationship, just talking about services, because I think this is an important thing for people to understand, is that when the child is born, obviously the child will be registered, making sure you have a GP, making sure that the school and everybody, all those people that are essential in the day-to-day life of that particular child that is born in this country, and obviously the siblings and everybody else, that those professionals are aware of the circumstances. That's correct, yes?
And they are going to mention in their report.
Yes.
So the same circumstances which they have been going through, they are going to mention in their report. They are not going to write something which they are not aware of. They will be writing something which they have been aware of. So this is the report the Home Office is going to consider it, and it's very important. If your basis of the case is not strong, then you won't be able to get success in your appeal.
And what kind of things would these professionals write about? Because, I mean, having a relationship with the GP, we would go to our GP if we've got a cough or a cold or nothing. Most people go to the chemist now for a cough or a cold. It's ailments, but you're not going to see your GP just for the fun of it. You're going to see them for services. So what kind of things will they mention in the report, just so that our viewers are aware of making sure that these professionals, because the reason for this is the fact that they are credible people, they are professionals, and their word has a legal status, a sound status within the system, isn't it?
Yes, and if the parents go to the professional people and explain why do they need this kind of letter and what needs to be mentioned in the letter. This will be something which they have been reporting to the professional already.
Okay.
So if, for example,
so it's nothing new. It's nothing new for them.
This will be nothing new, and they will be just giving the reports whatever have been mentioned to them already. So this is first thing in relation to the reports. And the second thing is in relation to the English language requirement. So these kind of applications is very important, that the applicant, for example, the child's parents complete their English language courses.
Okay.
However, if they cannot complete the English language course, still they can submit the application under the human rights, because under the human rights there is no strict requirement of submitting the English language test.
Because that's one of the things that people are quite concerned about, as we've spoken in all applications, is that they make the attempt. Obviously they're living here, they are a citizen here, but there are different reasons for them not being able to provide evidence of their English language.
But this should not be excused. If they can pass the test, it's very important to pass the test in this country. This will give them an extra edge to their application.
Okay.
And this will be an extra edge to the success of their application. So they must pass the English language, but for some reason, if they cannot pass the English language, they have to tell the reason. They have to get the psychiatrist report. They have to get the GP letter that mentally or physically they were not able to pass, or they were under the 18, or they were over the 65 years old. So therefore, they could not pass the English language test.
Okay, so for those siblings, in this particular case, so the child falls into the 7-year rule policy. For siblings, if they are under the age of 18, they don't need to do the test. And for those applicants, if there is
if parents are over 65 years,
then they are exempt as well.
Exempted.
But between the age of 18 and 65, they must have strong reasons for not being able to
for not passing the English.
What is seen as a strong reason? I mean, we touched a little bit.
As I just mentioned before, it could be that there could be some issues with mental health. They can get the psychiatrist report, or they might be able to get the GP report, as I mentioned earlier. And the second thing I would like to highlight is it's very important in relation to the sibling. For example, the rule is when the person who is not living in this country since his or her birth, and who came to this country as a child, and then he's over 18 years old.
Okay.
So in this situation, they have to spend more than half of their life in this country.
So this is a sibling.
So this is the main, rules under the immigration rules. However, if somebody wants to apply under the 7 years rule category, even if those siblings have not completed that more than half of years their life in this country, still they should be able to meet the requirement under the 7 years rule as a sibling of the person, of the child who was born in this country.
Okay. Now, within this category, obviously, that you've got test 1, which is the 7-year rule itself.
The test 1 is the requirement of a relationship. And the test 2 is eligibility of reasonableness test.
Yes.
What's the reasonable to grant the application to the child and their parents?
Okay. Now, what about the maintenance side of it? Because this is something that obviously people are concerned about. Do they need to show any kind of maintenance, or do they need to show any kind of financial information in order to live here? Because depending upon their previous, in terms of immigration status, they may or may not be able to work in this country, for example. Many asylum, if it's an asylum case, they may not be, and they may have exhausted that path of asylum or exhausted other immigration rules, and they may not have been granted permission to work. So is there any requirement there in terms of maintenance or financial?
There is no requirement such as £18,600 in this kind of applications, and there is no requirement for maintenance for the first child 3,800, and for the rest of the children 2,400. There is no such requirement.
No requirement.
However, the Home Office will want to see the maintenance as a general. For example, if they are just living in this country, if they are working, can they meet the expenses to live in this country? So I will say preferably they need to show some kind of maintenance But if there are circumstances they cannot show at all the maintenance, still they should be able to get the leave to remain in this country, because the main things, as I mentioned before, there are two things. The first one is requirement of a relationship, and the second one is that this will be unreasonable to remove the child from the UK, and they will not be able, they may not be able to live in the other country in the same standard like they are living in this country.
Okay. Now, in terms of maintenance, if family are supporting them, because obviously they're living here, they must have some kind of money or support to be able to live here, food, clothing, etc. And if family are supporting them or friends are supporting them, and in some cases there may be overseas people who are supporting them, so they may have money that is being sent to them from a parent or a family member, all that, is that credible evidence?
And sometimes if their application is failed asylum, like failed asylum application,
yes,
they are failed asylum seeker, they might have been receiving the income support from the government agency, asylum support from the government agencies. That can be taken into consideration as well.
Okay.
So there is no hard and fast rule in relation in terms of the income threshold requirement, but they must establish it
living costs.
Yes, I will emphasize again that this is the must requirement to show this will be unreasonable for them to live in that country. It could be that if they are removed, there will be threat to their life in the home country. It could be if they're removed, there will not be medical facilities available for those kind of people. So these could be some of the grounds that they can rely upon, but this is just one or two grounds. When somebody has to submit the application under the 7 years rule, they must get the specific advice from their own solicitor or lawyers.
Okay, so that is in terms of the 7-year rule policy. What are other applications that they may be eligible for, other than the 7-year rule policy, in terms of human rights?
7 years rule policy not only come under the human rights, but they've just tried to incorporate in the immigration rules as well. So it's mixture of the immigration rules as well as human rights. But mostly this kind of application is considered under the human rights applications.
Okay, we're just going to go to a break, and we've had some comments coming through. We'll have a look at some of those comments, and then we'll continue our conversation about human rights and human rights applications. So if you are somebody that has exhausted all applications, whether any kind of immigration application, or whether it be an asylum application, a refugee application, and you've exhausted all those in terms of possible avenues to get an actual legal status in this country, human rights application may be an actual application that you may be eligible for, and that's what we're talking about today. So we'll take a quick break, and then we'll come back after the break and continue our conversation about knowing your rights on human rights applications. Thank you. Welcome back to Knowing Your Rights, where today we're talking about human rights applications. Now, just before the break, we were talking about the 7-year rule policy. Now, Barrister Shazia, can you just tell me about what kind of people are eligible within the human rights categories, and what sort of requirements they have, or proof in terms of that they need to show in order to fulfill the requirements? So we've spoken about children. So children is one category, is those that are born here, and they meet the 7-year rule, but then siblings, are you...
There are the other types of the people who can submit their application under the human rights, and those are adult dependent relatives.
Okay.
So adult dependent relatives could be mother, could be father. Adult dependent relatives could be brothers and sisters as well, who want actually to come over to this country as a dependent, who need to have care, who needs to be cared. So this is another category of application. This does not come under the 7 years rule policy. Some people may not have their children born in this country.
Okay.
And some people may have their children in this country who, for example, who are adult people, like British people, and they want to call over their parents, their mother in this country. So this is where adult dependent relatives, they need to show the dependency upon the British citizen people.
So what kind of dependency can they show then? So these are now, they were possibly children when they were left in that country, then became adults, but their other family members are here.
Acquire the British nationality. Yes. So British national people are in this country. They want to call over their parents, and they want to call over their brothers, sisters from the other country. So
but they are adults.
They are adult as well. So people who are living in this country, they are adult as well.
Okay. Okay.
So this kind of application could be, for example, on medical grounds. They need care, day-to-day routine. They need to have proper medical treatment, and they need to have the care from the people from this country. So this is the test they need to show from their home country, that they want to come over here to receive the care from their other children who are British in this country.
Okay.
And who are over
so somebody,
18.
Barrister Shazia, somebody here who's British, who's working, who's established here, got their own life here, and they have an elderly parent in let's just say in Pakistan, India, wherever, and they are providing for them, and that parent, adult parent, is dependent upon them.
Yes.
And they have family there as well, but they're dependent upon this particular child. How do you prove that? Because
this is very important. They need to prove that they are solely and wholly, they are dependent upon the British citizen people.
Okay.
If they have family there, those family members can look after those adult people, they won't be able to pass the test. They won't be able to come to this country under that category, even if they have paid so much fee. You know, this kind of application, the application's fee will be £3,250 plus health surcharges.
Yes.
So, but still, you need to show that if you are coming to this country, then you will be cared from the people who are already living in this country.
So if they have...
And nobody is, a no suitable person is there to look after them in their own country.
Okay, but sometimes, Barrister Shazia, there is a suitable person, but they're still relying financially on the British citizen. So they could have a daughter who's married but comes and looks after her mother. Obviously, no one's going to leave their parents if they have any. It could be an extended family member. It could be a nephew or a niece that comes and checks on them. But that elderly parent is actually living in that country on their own in that home, but has other people coming to care for them. But ultimately, if they didn't have the support of the British citizen, they wouldn't be able to do that.
That's something, I think these are the categories of the people who are dependent upon the European national, not upon the British citizen. So they are different than the British citizen requirement. So for British citizen people, they have to show that they are dependent physically, financially onto the British citizen. But if they are applying on behalf of the European extended family member, then they...
No, if the British, I'm asking about British, I'm thinking of instances, and I'm sure people out there can think of instances where they have an elderly parent back home and there's nobody left at home. They ask somebody to come and check on them because they're by themselves. They provide all the financial care. They may go after 6 months, they may go after a year, they might go... And I know of cases, I'm sure you know, Barrister Shazia, of cases where people have to go there for a few months and come back, but when they come back, every day and night they're worried about their elderly parent, because if they have a fall or a slip, who's going to look after them?
So if somebody is not there to look after them, then this is a strong case. But if somebody is there to look after them, then they might not be able to get the visa, because this kind of visa is not for everybody.
Okay.
So they have made it very strict So you have to pass the test. You have to show that you are wholly and solely dependent upon the person who is British citizen. So the adult dependent are dependent not only financially but also emotionally, also physically.
Okay.
So this is something you need to, unfortunately, you need to show the evidence.
And how do we do that, Barrister Shazia? Because obviously we have professionals here, like you said, in terms of doctors and health professionals, social services. If it's an elderly person, you will have an array of people that will be looking after them. In some of these other countries, it's all private care, it's all it's care, you're relying on certain people. How do you show credible evidence from those countries? What sort of evidence? Because the burden of proof is upon you, isn't it? So that you have to show the proof. How do you show that as evidence?
I mean, it's not like somebody is not able to get the medicine from that country. So then you need to get the evidence on letterhead.
Okay.
If you just state it simple, then nobody is going to believe on you. So you have to just get the evidence from the hospital, from the GP, from the doctors or MBBS doctors on their letterhead that this kind of application, this kind of medicine is not available in that country. And for this kind of disease, they will require a particular medicine from this country, which is only available to this country.
Okay. I mean, that's a special category, isn't it? But I'm talking about just an elderly person who is receiving, might be diabetic, might have high blood pressure,
they won't be able to get the visa just upon these kind of general diseases which are easily curable in those countries. So there has to be particular reason, specific dependency. If somebody is not able to do cooking, cleaning, care on daily basis and nobody is there to look after them, then this could be.
And how do you prove that in those countries? Because here we have social services come out. There you don't have anybody. You're just relying on other people. So how do you prove? How does somebody gather that kind of evidence? I'm trying to give people ideas of what kind of evidence would be used.
This is so simple because if there is nobody living there, you need to show that how many family members are living there.
Okay.
And if nobody is living there, you will need to state it in your statutory declaration. You need to sign affidavit. You need to just make a statement of truth. And also you need to provide the family registration certificate where you will be showing how many family members will be living, might be living in that country, how many family members are living in this country, how many family members are available for them to care. It's very easy to identify or to just trail from the evidence. So they are very intelligent people who just look into the cases. So this differs from case to case. So this is the second kind of application.
Yes.
And now we need to just tell the audience about the third kind of applications which will be considered under the human rights.
I just wanted to ask you about, in terms of we talked about partners and marriage, but also if you're living with somebody as a partner, then they too are eligible within the application, aren't they? Because we have this culturally, we have this in our head that you have to be married. But if somebody is your partner and the application is for the family union, then that person can also be considered. Is that correct?
You know, this is something, for example, I really wanted to highlight this point that if somebody does not fall under the category of marriage application, then they can submit the application under the human rights basis as a partner of the person who is a British citizen. Okay. So if the person is partner who is a British citizen, then they can submit the application under the human rights. If they cannot meet the English language requirement, if they cannot meet the financial requirement, £18,600, and they are living together in this country, they can still submit the application, but they will have to use a different form which will be FLR-FP, not FLR-M. So this is very important. If you use FLR-M application,
that's for the marriage,
then you will have to show £18,600 requirement. Okay. And if you apply on the FLR-FP, which means you are applying under the human rights, and you will not need to show £18,600, and you will not need to, you are exempted from the English language requirement as well. If you cannot pass the English language, then this is the best application you apply under the FLR FP, under the human rights basis. So if the form is different, the requirement is different, then you will be able to get the status in this country.
And really, your legal person, your solicitor, barrister or advisor is the best person to help you assess your circumstances and which category you come into. Because if you, like you said, if you fill in the wrong form and you don't meet the requirements, then obviously you're going to fail.
You're going to fail, your fees will not be refunded, and you will waste your money. This is very important, that if you do not fit under one category, you need to assess which category you fit into. And sometimes people cannot even submit the applications, not only FLRFM, not only FLRM, FLRFP, then there will be third kind of applications which can be FLRDL, and this is called discretionary leave. In discretionary leave, people who failed their asylum applications, they will still have the right to submit their applications under this kind of form, under this kind of human rights, and then their status will be considered. They will be granted, after assessing their evidence, they will be granted the leave to remain in this country for 2.5 years.
So let's talk about discretionary leave, because obviously that is a different type of category. So people who have gone through certain categories, and discretionary leave, what does that mean? What sort of circumstances should people be thinking about or considering when it comes to
the discretionary leave? Does not actually come under the immigration rules, and this is not absolute right. You cannot just get this application granted as per your actual rights.
Yes.
So this is the Home Office discretion. When they assess your application, if you have medical grounds, if you have, for example, have been victimized of trafficking from other country, then you can complete this application, submit this application, and you will be granted leave to remain in this country.
Okay. And for this particular category, in terms of discretionary leave, what are the requirements? I mean, how do they, in terms of what sort of evidence would they provide, and what are, in terms of the test, in terms of how, for them to meet those requirements?
If they are applying under the category of failed asylum, obviously they will need to show why they should not be returned to their home country, even if they do not meet the requirement under the convention, Geneva Convention, but still they should be able to be granted leave under the humanitarian protection. And if they are not considered to be protected as a humanitarian protection, still if they can show that they have some medical reason, medical grounds, they need the GP services from this country, they will not be able to get the same kind of services from their home country, then this means that they need to enclose this kind of evidence with their application, all the bundles, and then they will submit this application. The Home Office will consider the circumstances, and then they will reach to the decision whether this person is credible, this needs to be, this person needs to be granted a leave to remain in this country.
What we find with a lot of these cases, information that comes across, is that people have gone through one application, failed, appealed, putting in a different kind of application, failed, appealed, and this has gone on for such a long time. For those people who are continuing trying, does the Home Office look favourably upon these people who are moving from one category to another?
There is no such rule that the Home Office will go beyond their powers, because this is something, if somebody is submitting the application under one circumstances and tomorrow the circumstances are changed, they are allowed to submit the application in different category.
Okay.
As I have been advising before, if the application does not fit into the one category, it might be that they will be assessed in the other category. It just, all they need to show is their credibility and their circumstances and evidence that matches to their circumstances.
Okay, so in terms of types of applications, generally speaking, under human rights, how many different types of applications are there? Are there many different categories and types, or are they generally speaking?
Now in these days they have categorized the applications into 4 categories.
Okay.
The one can be leave to remain in this country as a spouse,
Okay.
spouse application. The other one can be as a partner, as a parents, And the third one could be if somebody wants to apply as a dependent, adult dependent. The first dependent application we've talked about from the outside of the country.
Yes.
And this one, if somebody is here and cannot go back, they are here as a visitor, and there are very special circumstances, exceptional circumstances, they cannot go back, then they can submit the application from this country under the human rights application. So this is called FLR HR application.
And what are those circumstances? Can you give an example? So these are people who are a sibling or a relative. Well, it'll be a sibling or a parent of somebody who's born here, but may not have their status defined yet. So they're putting an application with that application. So what kind of...
this one we were talking about, the third one application.
Yes.
So the fourth one will be the discretionary leave, FLR, DL, where we've just spoken about the medical grounds. If somebody has been trafficking or have been actually made slave and have been brought to this country and they cannot go back, they need to show, they need to prove why they have been brought to this country. And if they have been brought by an agent, so they will be able to submit the application under the discretionary leave. So these are the four categories of the applications the people can submit under the human rights basis. One most important thing is if somebody cannot make payment to home office fee.
Yes, I was going to ask about that because maintenance is very important, isn't it? And one of the things that often deters people from putting an application in is their financial circumstances. As somebody who's under a human rights category, who's a sibling or a child or a parent and has no fixed financial income, is relying on other people.
Yes,
it's a lot of money, isn't it?
It's lots of money. Some people ask me, we are 5 family members. We have to submit the application under the 7 years rule policy. And if there are health surcharges, £1,000 each person, 5,000, and over £1,000 home office fee, 5,000,
and the legal fees,
and the lawyer's fees, it may be £15,000. So if people cannot afford to pay that, then it's the Home Office has actually created a policy for those people who are destituted and who cannot pay the fee. Then they will have to submit an application before their original application, online application, and this is called a fee waiver application.
Okay, so let's talk about the fee waiver application, because I'm sure there are many people out there who are absolutely destitute, want to put in an application and may not be in the system, as in openly in the system, because they're scared. And the one thing that deters them from putting an application is the financial. So what kinds of circumstances will the Home Office consider?
The test for fee waiver application will be if person cannot meet their initial expenses of day-to-day living. For example, if they cannot afford to pay their bill, their electricity, their heating bill, and they have no sources of income, and they have no saving. So if they can enclose their bank statement, they enclose their own statement signed by a statement of truth, then they can just prove that they have no savings left and they are destitute people, but they can meet the requirement of there are good chances of success in this application. So the Home Office will consider if there are good chances of success in their application and they cannot afford to pay the fees of Home Office, then they will grant the fee waiver. Afterwards, they will be able to submit the online application without paying their Home Office fee and health surcharges.
And what about the legal fees in terms of lawyers or barristers' fees? What happens with that?
If they cannot pay the lawyer's fees, there will be 2 or 3 options for them. The first one will be they can go to Citizen Advice Bureau and get the free advice from there. They can go to a legal representative and pay them the consultation charges, might be a couple of £100, and they can just get the advice and templates and all the written advice, documents, list of documents. They can prepare their applications by themselves
and put it
because instead of just putting the wrong applications, I will advise to get an initial consultation from the legal representative by paying them the initial consultation fee. This will be where you will be able to get the whole idea idea whether or not you qualify under those applications and what kind of forms needs to be used, and the procedural matters you will be advised for those.
One of the things that often people think about, in conversation when I have with them, is that...
Sorry, the third thing is, if somebody cannot pay at all something, then I will advise them to go to government.uk website and just to type the FLR HR form, and then you will be able to look into the form, complete the form, and enclose the evidence which will be just mentioned within that form, and submit your application for free.
Okay, so you'll be able to meet that. What I was going to say, one of the things that people try and do is to try and prove in these kinds of applications that they don't want to be a financial burden on the state. So this is where often they hide the fact that they can't afford it, and they borrow money, and they get themselves into debt, and they try and put the application in and pay the fees because they're thinking that, okay, I need to stay in this country because of my circumstances. I may not be able to go back because of my human rights issues. But the financial side of it, they want to be like a hero and prove to the state that I am financially independent. Does that make a difference?
If they are able to borrow money from somebody, yes, they should be able to pay the fees, because these are the certain questions they will be asking in the fee waiver application.
Okay.
So they will be asking whether or not you are able to borrow money from somebody, because tomorrow, if you get the right to work in this country, then you can work and return back money where you've borrowed from. So if you are able to borrow money from somebody, then you should be paying the fee. But if you cannot pay the fee at all, then this is where you are qualified to get eligibility for fee waiver from the Home Office.
Final words, Barrister Shazia, lots of information there. If somebody has exhausted all avenues, they've gone through the immigration rules, they've not been successful, they have children that are born here, maybe some children who are born outside of the country, what should be the first step in them actually considering putting in an application on human rights? So
there are two reasons. The first reason is, if they have no ground to stay in this country, they should go back to their own country. But if they have reason to stay in this country, and there are compelling reason, even if sometime the child could be under the 7 years rule, but there are compelling circumstances, there are issues of humanitarian protection, so still they should be able to submit the application under the private life, under the actually human rights basis, and under the compelling and compassionate circumstances. This is where they can submit the discretionary leave to remain application. And finally, I would like to say to the audience, and we should have actually said before, this is very important, that now this is good news for those people who have been living in this country for the last 10 years.
Okay.
And now the new Prime Minister, actually Boris Johnson, has made a statement that they're considering amnesty to legalize those people who have been living in this country for the last 10 years.
Okay.
Because before the policy was 20 years rule.
Yes.
And now they've changed, they are going to change from 20 years to 10 years.
So this is under consideration, is it?
This is under consideration, and this is going to be amnesty for those people who have been living in this country for 10 years, and they can be legalized themselves after the policy is announced. But they have to show that they have been living in this country without any criminal record, and they have good character history. So it's very important to show good character history. That's all you need to show. Then you will be able to get your settlement status in this country after that policy is announced. So this is good news for them.
Yes, absolutely. This is very good news. So thank you, Barrister Shazia. Thank you for sharing that news. And what is going to be the next topic that we're going to be talking about next week? Have you decided what we're going to move on to?
My ambition is always to give the awareness to people in complex areas where they cannot easily find from the internet or from the other websites. So these kind of applications which are like asylum applications, so maybe extended family members of European nationals, or under the rules which are not covered under the immigration rules. So those kind of applications, for example, people sometimes think if they are overstaying in this country, they have no right to stay in this country. There might be some circumstances for them to stay in this country. So next topic might be the asylum seeker, their family member, or reunion of their family members from the other countries.
Thank you very much, Barrister Shazia. As always, very sound advice. And we always say that this is very general advice, and before you make a decision on what kind of application, it's very important to get proper legal advice, and whether that be a solicitor, a barrister, or Citizens Advice Bureau, just as Barrister Shazia said. So please make sure that you do take proper advice, and inshallah there'll be a way forward. So for today, we thank you very much, Barrister Shazia, for the advice that you've given, and inshallah same time next week we'll bring another program and continue our conversation about knowing your rights when it comes to immigration law. Thank you very much.